everyone, it's Alan Stewart with your Real Estate 101 tips and advice for the week of July 7th, 2014. Last week, I'd asked if you'd share some suggestions with me about topics that you'd like to see discussed more in these episodes, and I received a great question from Stephen in our North Vancouver office. Stephen asked that I expand a little bit on how to handle estate sales. There seems to be a lot of them going on right now. I'm not quite sure why, but we're seeing a lot of sales from estates. So there's a few things you need to keep in mind when you're representing either a seller or a buyer. Did you know that the power of attorney ceases to have any effect on death? So if you're representing an estate via a power of attorney from someone, you've got a problem. The only people you can look to for instructions on selling an estate property is either the executor of the estate or the administrator. And what they have to have in order to transfer title is either a grant of probate from the courts, which would be given to an executor, or letters of administration, which would be given to an administrator. And without one of those two documents, you can't transfer title of the real estate. When you're listing a property with the MLS, it's important to remember that you're going to need to receive a copy of the first page of the will that will clearly identify who it is has the authority to bind this estate to the transaction. The real estate board is going to require a copy of that to be sent in with the listing package before they'll process the listing. Once you've got that taken care of, we can move forward with advertising the property for sale and entering into contracts. However, you need to remember to include a subject. The subject's relatively straightforward and you'll find it in web forms, but in effect, it just states this is a subject for the sole benefit of the buyer, by the way. The buyer, subject to the buyer receiving on or before, and then you pick a certain date, and you need to get some instructions from the lawyer for the estate as to what might be a reasonable date. However, once there is an offer in place, we've been told that the process is sped up for those estates that are waiting on this grant of probate or letters of administration, that those move to the top of the list. So I'd suggest 2 or 3 weeks will be required in order to get those documents, but once again, check with the lawyer for the estate who should be able to give you a better time frame. It really depends on how busy the courts are. So once we've chosen that date, subject to the buyer receiving on or before this date, a copy of the grant of probate or the letters of administration, and confirmation from the executor that nobody has put a claim against the property under the Wills Variation Act. There is risk that someone could put a claim against the will and state that they are entitled to something more than what's laid out in the will, and if that happens, it will cause frustration at completion. So your buyers need to receive either a grant of probate or the letters of administration and confirmation from the executor that no one's contesting the will. This subject, of course, is for the sole benefit of the buyer. You'll find the wording in web forms, and it's required if you haven't received those things, the grant of probate or the letters of administration, before moving forward. Now, when we're listing a property and taking that multiple listing contract, what you want to do is have the executor sign in a very certain way, and it's the same way he would sign on a contract of purchase and sale. And it would say, Joe Smith, executor or administrator, for the estate of, and then the name of the deceased. That's how he's going to sign at the bottom of the contract or on the listing agreement. I had another great question that came to us from the Sunshine Coast, and I was asked whether or not a property needed to be maintained all the way up until closing in terms of the gardens and the yard. Well, it's important to remember that when someone takes possession of a property, they've negotiated for it as viewed on a certain date. And so whatever condition the property was in when they viewed it is the condition they can reasonably expect to be receiving it in at completion. So if you're talking about a big acreage with lots of yards and gardens and all those kind of things, and the completion isn't for a couple of months, as a buyer, you may want to reserve the right, or the buyer's agent, reserve the right for your clients to go through and have an inspection of the property a few days before closing. But the buyer may well want to have some kind of recourse in the event that the yards and gardens aren't maintained. It could be a minor issue, but obviously on bigger properties it could be a fairly expensive one to rectify. I received a rather unfortunate phone call the other day from a client who claimed to have been promised a referral from one of our realtors. Now, it's important whether you're paying or receiving a referral that you will always put the details in writing. I don't care if it's by way of an email, a fax, or a commission referral form, make sure that you get the details in writing. Just a reminder, when it comes to deposits on offers, please don't have interest-bearing trust accounts set up for the benefit of deposits unless they are in amounts of greater than $100,000 and are held in trust for over 60 days. Did you know that a $50,000 deposit held for 30 days would generate about $8.50 worth of interest? So it's important to not put us through the onerous task of setting up an interest-bearing trust account, which costs a great deal of time and money. Rather, we'd prefer that we save those for situations wherein we have a lengthy closing and a substantial deposit in place. Appreciate your help on that. I had a really interesting conversation with Maureen Coleman, the compliance officer at the Real Estate Council of British Columbia the other day in regards to the disclosure of interest in trade. The question was put to me by a realtor who's looking at purchasing a property that doesn't complete for 10 months, and they're not exactly sure what their plans are going to be in 10 months' time. It will be really dependent on the market. They may rent it out, they may look to sell it in 10 months. So the question we put to Maureen was, is it fair that we have to put ourselves in a negative position by stating we're going to contemplate selling the property for profit when we're really not sure? And Maureen had an interesting response. Turns out that the matter was put before the courts, and the Real Estate Council was surprised by the findings of the Supreme Court. In this case, a property was purchased by a realtor and who went ahead and sold the property down the road because his personal situation had changed. He couldn't afford to hold on to the property, which was his intent when he purchased it. So 6 months after buying it or so, he flipped the property, and the seller found out about it and came after him at court and was successful. Therefore, the Real Estate Council, having to rely on the findings of the court, also had to take action and suspend the realtor's license. So Maureen's recommendation is, if you're not absolutely sure in this case, if you're purchasing a property and you're not sure what you're going to do with it, tick both of the boxes. Realtor is going to hold the property for personal use, and or the realtor is going to contemplate selling the property. Tick those both off, and then somewhere on the disclosure of interest in trade, make a notation stating quite clearly that the realtor is not absolutely sure of their intentions at the time that they've entered into this contract of purchase and sale, and reserves the right to sell the property while that may not be their intention at the day of closing. So a tricky situation. Don't forget that you need to protect yourself by ticking both boxes off when you're doing your disclosure of interest in trade, unless you are absolutely sure what your intentions are for the property. All right, I want to ask you a really challenging question, and I want you to take your time in answering it and be really honest with yourself. Here's the question. How many times do you follow up with a potential lead? And I know we're all cringing right now, because while I'm hearing from realtors that leads are what we need, what you really need is to convert leads into sales. That's the critical component. And we, in this business, according to a recent study in REM magazine, fail to follow up with leads to an extent that's just shocking. Did you know that 48% of people are not contacted after the first engagement? So 48% of leads are not followed up on one time. We meet them at the open house and that's it. See you later, nice to meet you. Won't be talking to you again. That's too bad. It's really unfortunate. 27% of realtors only follow up twice. That's it, and then they give up after 2 contacts with a client. 12% of realtors follow up a third time, and only 10% of realtors will follow up more than 3 times with a potential lead. That's a sad state of affairs because only 2% of all buyers, 2 out of every 100, actually purchase after 1 engagement. So in other words, they come through an open house, they love it, they want to buy it, they ask you to write up the contract. 3% buy after 2 engagements, still a very low number. 5% buy after 3 engagements, 10% buy after 4, and a staggering 80% of people buy after 5 engagements with a real estate salesperson. So if you're not following up with a lead up to 5 times, you're missing out on 80% of the buyers that are out there. If you give up after 1, 2, 3, 4 phone calls, you're really cutting your odds of being successful. Turns out 5 to 12 contacts with a client is usually what's required before they make a purchasing decision, and that could take anywhere from a couple of days to a couple of years, as many of you can attest. So it's really important that you harness your leads, put systems in place that assure you're going to follow up and provide those people with good quality information, and make sure that you befriend them, that you take them into your inner circle and you treat them like gold, because every lead is golden. It's just a matter of getting them to the finish line. So how do we work on our conversion? Well, Verl Workman from Corcoran Consulting, who wrote the article ABC of Lead Management in the REM magazine that I was describing earlier, suggests the following. He suggests that you break your leads down into 3 different types. This is what professionals do. You break it down into 3 different types. We have A leads, B leads, and C leads. Our A leads are leads that we have appointments set with. So it's people that we've been out in the car with. When we finish showing them properties and they fail to find the right property, we set an appointment to go out and do it again. Or they find something they like, we set an appointment to sit down and write up the offer. So they're people that have appointments. Those are your A leads. Those are your bread and butter. Those are the people you have to remain close with by setting appointments. B leads, Verl recommends, are followed up with twice a month, and he recommends you break your calendar down as follows. Weeks essentially start the 1st, the 8th, the 15th, and the 22nd of the month, right? So that gives you 4 different separate categories for the month. Verl's recommendation is that your B leads are followed up with on the weeks of the 1st and the 15th. So every couple of weeks, you're following up with those B clients, people who are considering buying or selling in the next 30 to 90 days. That's what defines a B client. And you're going to contact them in the first week of the month and the third week of the month. Then your C leads are people who are more than 90 days away from making a buying or selling decision. Those are still worthy of pursuing, but you only contact them once a month. And Verl's suggestion is that you make contact with them on the day starting on the 8th. So that would be the second week of the month that you're going to be reaching out to those C leads. And then your sphere of influence, the people that you're trying to build up your referral business with, are followed up with on the 22nd of the month. So that would be the 4th week of the month. So that breaks your month down into 4 separate weeks that you're going to start pursuing and following up with your leads so you don't drop them and miss out on an opportunity to close. I agree with Verl that our problem is not in generating leads, it's in getting leads to the finish line. And I think his system of following up twice with people that are B leads and once a month with people who are C leads or your sphere of influence makes all kinds of sense and allows you to put some structure around how you're going to get in touch with people and what you're going to talk about.